Esperasas. My name is Loizou and welcome to this week's Family Law Show, brought to you by the International Family Law Group. In this week's programme, we're going to be looking at some general principles that apply when a parent seeks to relocate abroad with their child following the breakdown of a relationship. Over the forthcoming weeks, we're going to cover a number of other different family law topics. This is to include divorce, finances on divorce, how the care arrangements should be dealt with following a breakdown in a relationship. We're going to look at some of the alternatives to going to court, to include mediation, how the law applies to unmarried couples, as well as a number of different family law topics. I will be your host. I am a solicitor and a partner at the International Family Law Group, and some of you may be familiar from my work from London Greek Radio. Over the last 3 years, I've had a fortnightly radio show where members of the community have been calling in and have been asking various questions about family law. I also write a monthly column in the Barigiagi newspaper, as well as a regular blog on other internet websites about family law. I work at the International Family Law Group. We're a specialist niche practice in central London, and we're based in Covent Garden. We provide services in relation to family law to both national and international clients. Most of the work that we do has an international element. So moving back to today's programme, I'm joined in the studio by Anne Thomas.
Hello.
Hello. Anne is our managing partner at the International Family Law Group, and Anne has been practising law for a number of years now. She's one of the country's leading specialists in international children cases. Anne, welcome to the studio.
My pleasure, Lucy.
So in terms of our programme this week, I'm going to be asking Anne a number of different questions, and she's going to be giving our viewers some guidance and tips in relation to international relocation and how this applies on a breakdown in a relationship. So Anne, if we begin, if a relationship breaks down and there are foreign elements in a case, so you may have a Greek couple, it's not uncommon in the work that we do that one of the parents might want to relocate back to Cyprus or Greece, for example, with their child. Should they just do that? Should they just go?
Well, Lucy, the best advice I can give is no to that. There's nothing to stop the parent who wants to relocate to go with the permission of the other parent and anyone else with parental responsibility for that child or for those children. So first of all, obtain consent from the other parent or all those with parental responsibility. I wouldn't rely on that consent being given orally. I would make sure it's written down as the next step, which is going to be the best way of proving that consent's being given. And then the next heightened step from that is to make sure it can be written down in a solicitor's letter. So one solicitor would say to the other, my client wants to relocate to, your examples, Greece, Cyprus, etc. Your client consents to that, or does your client consent to that? If the answer is clearly yes, let's have that in a letter from their solicitor, and then you should be fine. If there's issues, you think an issue is going to crop up in the future, what I would suggest is that by consent, again, if the other parent does agree, that you make an application to the court and you get that consent to a relocation written in a court order, and that is a permanent, as permanent as it can be. I think if consent isn't forthcoming, the only other option is for that parent wanting to relocate to another jurisdiction to be able to make the application to the court, and then you've got a contested court hearing coming along, and I know you're probably going to touch on these later, but they can be very difficult for the future relationship of that family.
Right, and you talked about parental responsibility. What is parental responsibility? How's that defined?
Parental responsibility is basically an order or direction allowing a father or another person to have full rights in respect of that child's life. For example, rights to have a say in the sort of education that the child will have, a right in the religion that the child is going to be brought up in. Those major decisions that have to be made in respect of a child can be made with everybody with parental responsibility. A mother, obviously giving birth to a child, her own natural child, has parental responsibility as of right. As soon as the child is born, the mother has parental responsibility. And if you're in a married relationship and the child is born within that marriage, the father of that child also has parental responsibility. But if somebody is born out of wedlock, then they have to acquire parental responsibility, and that's done by either the mother completing a parental responsibility agreement and the father completing his part of that agreement and it being registered in the court in London. If parental responsibility isn't given by the mother, then the father, provided he can prove he has a good relationship with that child or those children, can make an application to the court for parental responsibility. But parental responsibility doesn't give the father, in that example, any other rights other than those very big main decisions, the day-to-day issues that the parent with whom the children are going to be residing makes those day-to-day decisions with very little input from the father.
And bringing the concept of parental responsibility into these applications to relocate to other foreign countries. If a parent leaves the jurisdiction of England and doesn't obtain the consent of everyone that has parental responsibility, what are the consequences?
Very serious consequences, both in the civil law and the criminal law. If a parent leaves the jurisdiction without the proper consent of all those with parental responsibility, and I said earlier it's a father with parental responsibility, but there can be other people with parental responsibility, children who live with grandparents for a considerable period of time, that those people can also apply for parental responsibility, may have it. All sorts. So you have to look back into, has anybody else been responsible at any time for this child, and if they have, there's a chance that they may have parental responsibility. It's not as of right. The only person having it as of right is the mother, but you have to look at the wider picture basically. But anybody taking a child out of the jurisdiction without the consent of all those with parental responsibility is committing a criminal offence under the Child Abduction and Custody Act, because you're taking a child without the consent or you're wrongfully retaining them for a period of a holiday. Say a father's given permission for the children to have a holiday for 2 weeks and the mother stays longer with the child. Well, that is getting into the realms of a child abduction. That's a wrongful retention, and that can be remedied by reporting the matter to the police. You can get Interpol involved as well if it's a very complex case, and it's a criminal offence of up to 7 years imprisonment or a very hefty fine. That's that issue. What also I'd expect a client who's had a child abducted from or kept out of the country for a good period of time to do is to make an application to the High Court in London for particular orders for that child to be returned back to this jurisdiction. You sometimes have to make some applications here. You sometimes have to make some applications in the other jurisdiction. It depends really on where the child has gone. It's too much to go into for a programme like this as to which countries are involved in that, but it's very complicated, and the most important thing is establishing the contact, and there's so much information I could say, but really if anybody's in that situation, before you leave, please seek advice before you go. If you want to relocate, plan your relocation in good time, and if you have had a child abducted, don't try and deal with it yourself. Seek advice from a specialist lawyer straight away. And what we'd also say is you can go to any lawyer to help you in cases where children have been abducted, the criminal aspect, the civil aspect, or where a child should be returned back to this jurisdiction. But always ask your solicitor, because you're entitled to know this, quiz them. How many cases like this have you done? What's your success rate? All those sorts of things are so important, because what you don't want is somebody saying, I'll have a go at a case like this, I can read the books, it's experience you're paying a lot for, and in these situations it's a one-off. If you get the child back, brilliant. If not, it can go on through the court system, through appeals, and then even some clients say, well, let's go to Strasbourg and try and get a remedy. All you'll get at Strasbourg is an apology if everything's gone wrong with the country that's made the application through, and a compensation, and it takes a lot of time. So all you really want is your child back at a very early stage, not to wait 2 or 3 years only to get an apology or a monetary compensation.
Yes. And I would say to our viewers, if there are concerns about child abduction and what that means, we are going to have a programme that purely deals with child abduction in the forthcoming weeks. So, and just looking at these relocation applications, if you want to make an application, what does a parent have to show in order to succeed in an application like that?
Well, the most important thing, a parent with whom the child is living can make an application to relocate. I'd always advise the parents not to rush into this. Take time, because there are various things you have to make sure you've got in place. I like to say in my practice, get the ducks in a row or get the eggs all in the basket. Make sure you've looked at where you want to relocate, where the child is going to be living. Most importantly, looked at the contact arrangements you're providing for the left behind parent. And I would always say that look at the children's best interest. The paramount considerations of the child's welfare are most important from the two leading cases that we're looking at. And make sure, as I say, you plan ahead, make sure you've got everything sorted out before you make that application. If you make the application too soon, I mean, people say you can make lots of relocation applications. Well, you can, but the way that we deal with it at my office is that you have one chance really to make that good application. So get it right from the start and don't rush into this. Make sure it's well planned, make sure you've done your research in the other jurisdiction, look at the language point of view, look at what you're taking the child away from and what can you offer them in the other jurisdiction. As I say, there's lots of other issues you can bring into this, but basically take your time to make those applications, and the time not to make the application is immediately during or following a divorce when you're saying, I've had enough here, let me go away, because that's the parents' wants and needs rather than what is best for the child, which the court is going to look at these days.
And if we look at the flip side, let's say commonly it's a father who's faced with an application from a mother to relocate, what can a father or anyone facing that situation do to defend such an application?
Well, advising fathers, as I do and as we do at the International Family Law Group, we say basically the first question I will say is, are you able to offer a home to the children? What is your contact like with the children? How often do they stay with you, live with you, stay overnight? And if that father hasn't got very much contact, the next thing I'm going to say is, if we can get the contact sorted out so it's all nice and solid, and you know you're going to get contact in the other country where the child is going to be relocated, by Skype, by visiting, by the child coming back here or the children coming back here, is that enough for you? And in some situations the answer is yes. And if it is, then use that relocation application to get as much contact as you can for that father. And that's the best way of dealing with that. You can get it into a court order. In some European countries, you can get it automatically recognised by the other European court. You mentioned Greece, a good example there. And in other jurisdictions, there's other things that one can do to make sure that the contact agreed in that order is reinforced in the other jurisdiction. You can have mirror orders, etc. So that's the first thing. Do you really want to go ahead and challenge this? Do you want to oppose that jurisdiction? If they do, then the next stage is, let's look at how you can anchor your children in this jurisdiction, but look at them as well. Look from the child's perspective. What is best for your child or your children? Is it to be ripped away from all they know here, to go into another jurisdiction? Is it just a holiday relationship they've got in the other jurisdiction? So you're looking at anchoring the child in terms of education here, relationships with his peer groups, all the little activities they have, guitar lessons, cricket lessons, dancing, swimming, all that sort of thing. And what you could offer that child in terms of residence as well. I think sometimes I would say that you've got to wear different hats as a lawyer. If I'm acting for a client who wants to relocate to another jurisdiction, the advice I'm going to give that client is going to be slightly different from the advice I give the parent who wants to relocate. What I'd also say in these cases is, if you go to a lawyer who is a specialist in these relocation cases, either bringing them or opposing them, you have very experienced people who know how to deal with these cases from a tactical point of view. I gave you an example at the beginning. Do you rush off and make that application straight away? Well, no, you don't. There are things you need to get in place first of all. Do you necessarily want to oppose the application? Well, not necessarily, but you might want to. So ask your lawyer about the experience they have, and tactically you can sometimes turn these cases. For example, a father might have a child staying for 3 days, 3 nights a week. What I might say is, would you like the child to stay for another day? And he may say yes. Well, that's turning that case a little bit. So you've then got a 4-night stay rather than a 3-night stay or a 2-night stay, and that's all the better for keeping a child in this jurisdiction. So it's not saying that you know, if I'm asked to act for mothers, I'm going to trick them or the other way. It's just looking at getting the experience you're paying for, experience, and that's the best way ahead in these cases, basically.
And over recent years, the law in this area has changed, and there is more of a focus on the courts looking at the shared care arrangements, and that has a stronger impact. Would you say that's right? And are you always looking at these tactical considerations early on?
I think you have to, and I think the best case where I can give the fathers the most hope is where they're both living in the same house. You've got father and mother still in the same house with the children, because nobody then is a primary carer. So one doesn't really have an advantage, for want of another word, over the other. So I think basically it's really important that you look at the home situation, you look at how much contact one is having, and if you can tactically turn those cases by increasing the level of contact, then fantastic, it's going to help your case hugely. And for the mothers looking at this case, I suppose you could say, oh gosh, perhaps I shouldn't be so generous with the contact. But again, what I would always hate to see as an international child lawyer is parents tactically moving these cases to the detriment of the child. You've got to look at the child first of all, and what is best for that child. If it's best the child relocates, then let's get the tactics round to force that issue if we can. If it's better the child doesn't relocate, let's think tactically as to what we could do to try and keep that child in this jurisdiction.
Yes. And just touching back on a topic that we looked at the start of the programme, let's say everything is amicable and you know, a mother or a father's given permission to relocate abroad. Should that parent get it in writing, or anything more than just writing?
In a situation where the other parent with parental responsibility does agree that the child can relocate to the other jurisdiction, it's enough. Sometimes a client will ring and say, well, look, I spoke to him last night, he said I can go. I would always say that's not enough. Get it in writing, and use the word permanently. What we've had is some situations where a client says, oh, I've got this email from my husband or my estranged husband or boyfriend. He said I could relocate to another jurisdiction. And when they show me the email, it says something about, I want to go to Greece. Well, you've got to say permanently to live in Greece. You can't trick them. It's got to be an unequivocal, definitely, yes, I want to go and live in Greece or Cyprus or wherever it's going to be permanently, not just in terms of a holiday. Really.
And in that kind of situation, let's say you have a left behind father, I guess it's also important to make sure that there's proper contact provisions in place, and maybe use that as a way of saying, look, if you're going to go, I want to have additional contact with my child.
I think that's right. And what the courts generally do, these cases don't always, but normally come to fruition near a summer holiday, and the judges like, if the child is going to leave the jurisdiction, to have a long period when the father can have contact if the father's going to be the left behind parent. And maybe you can have a longer period of holiday. So these applications are good to negotiate really fantastic contact arrangements, and where normally you can have the normal arrangement, if anything can be normal in any family, is alternate weekends for the non-resident parent and half the holidays. Well, realistically, sometimes people don't have the long holidays. What do we get these days? 16 weeks holiday a year? Yes. Many people wouldn't be able to take the holiday for 8 weeks or so. So we're looking for a good period of contact, and maybe if a mother is going abroad with a child to relocate, let's have the father having 4 weeks holiday here or there. Let's have the mother bringing the child in here for some of those extra holiday periods and build up that time. And I think, again, as you said, you touched on the change in the law. It used to be very much the mother's wishes and feelings in, would the mother be really upset if the child can't relocate to the other jurisdiction with them? And now we're looking really bringing the welfare of the child right up to the fore. Let's look at that child, not the parents' wants. And in all my statements, I will stop the parents if they're saying, I want to see this child, I want this. It's not your wants, it's the child. The child, it's, you know, the contact with the child and the other parent, it's the child that's really, really crucial, paramount.
And let's talk about the process and the time these types of applications take. Commonly, let's say parents can't agree, how long before a final decision is made? If
parents can't agree, and remember that once you've started court proceedings under the Children Act, it doesn't mean to say it's going to end in court with a final decision. At any point between the start of the application and the final hearing, I mean, that could be a year away, could be 9 months away. Sometimes if there's a court slot, you could get in a much closer period, but you're not likely to get these cases concluded in 6 months. But again, between the start of the application and the final hearing, you can agree terms at any point. If you agree terms at any point, you literally put what you've agreed in a consent order and then invite the judge, once it's signed by both parties and their lawyers, to make an order in those terms. And then sometimes, depending on the country, you have to be sure if they're going to Australia, for example, you've got obviously there's a Hague Convention that helps us with some of those other countries. Again, I'm not going to go into all that now, but some countries you can mirror an order, some countries you have to register an order, some countries you can't register an order, some countries have the automatic recognition of those orders in Europe and now under those Hague countries. But that is specialist advice that you need from your own lawyer at that relevant point.
And in terms of process, you issue an application, then we've got this time period up to conclusion. What happens in the middle? Are there a number of hearings? We often advise our clients about CAFCAS officers. What are CAFCAS officers? What role do they have in these applications?
In these applications, first of all, what the court would like to see is a letter coming from the party who wants to relocate to the other parent, setting out why they want to relocate and the terms of that relocation. I've known cases that are won or lost on the strength of that first letter. Okay, so it's got to be right. And if I'm acting for a parent opposing a relocation, if I see that that letter doesn't give good enough contact, I'll jump on that and I will keep bobbing into that all the way through the proceedings. So I think we have to think very carefully when we're making this application. The application goes through, it's served by the court on the other parent. Then there are various things that need to be done before that time. Is there any discussion going between the parents? Fine. Between the solicitors? Fine. The court will set a date, which is the first time the court will hear this matter. It's not going to make any decisions. It's going to set a timetable of things that have to be done by when. For example, the court will say, let's have a CAFCAS officer to make a report in respect of this child. The timetable would therefore be filing the application. There would be statements which would have to be filed by both parents. Normally the parent who wants to relocate goes first and the other parent who opposes answers that statement. Very important pieces of law to get right, because that statement is going to be relied on by the court in those situations. You then have a CAFCAS officer, which is somebody who makes recommendations to the court or to the judge as to what he or she thinks should be happening in this situation. So that CAFCAS officer, nothing to do with social services, just somebody who's used to getting into family situations, can talk to children, and advise and just work out what the relationship is like on the ground and what the child wants to do. If the child is old enough to be able to give very good instructions to as it relates to what they want to do, if they want to relocate or not, the CAFCAS officer should talk to the children and say, basically, you know, what is it you want to do? Do you want to go with mum? Do you want to go with dad? Once you've got the CAFCAS officer having seen the children, the report goes in. So you've got application, statement of applicant, mother, usually, sometimes father, respondent statement. You've got the CAFCAS report. CAFCAS officer looks at both those statements, and then the recommendation goes to the court. And at the end of the statement, normally there is a recommendation as to what the CAFCAS officer thinks is best for those children. If at that point, you can always say, look, can we agree now we've seen the report? If an agreement isn't made, then it goes back into court again for a final hearing, a very little hearing saying suddenly agreement can't be reached. A final hearing will be listed. It could be 1 day, 2 days, 3 days longer. I've known some of these cases going up to 17 days with lots of issues. And then it's determined at that stage, CAFCAS officer will go into court and say, I said this in my statement because. But if we're going into this procedure and you've got a CAFCAS officer who produces a report that says, I wholly recommend that this child is allowed to go to the other jurisdiction, that isn't the end of the story. You can still proceed with these cases. It's a strong indication of what the judge might do. If the judge wants to depart from what the CAFCAS officer says, the judge has to give very good reasons why that judge is not going to follow the CAFCAS officer's recommendations.
Okay.
And I think also in these cases, if you've lost a case, take advice very, very quickly, because there's a very short period in which you can appeal. If you want to appeal, you've got to make sure that you've looked at this very carefully. You've got to make sure that the judge has dealt with all those issues before that particular court, and you can't just say I don't like the judge's decision, because a lot of the appeal orders are coming through as being rejected because the court or the Court of Appeal will say, look, the judge at first instance heard the evidence of both parents, talked to the CAFCAS officer, in some cases heard the child, an old enough child, and it's not always you're going to get a change of decision. What you might get is a rehearing, but they're very, very rare indeed, very rare.
And I mean, with these cases you talked about possibly, settling after the CAFCAS report is in. Do you find that these cases, there's scope for mediation? Can there be mediated settlements?
Yeah, there can be mediated settlements. I mean, these cases are the cases that the judges don't like because they're so polarised, and
yes.
It's not like in the Bible where you can chop a child in two and give one half to one and one
yes.
and the other. You've got to try and work with this, and most important, you've got to try and keep within this child's life, because, you know, whatever decision you make at that stage, it's not ending the relationship with the other parent. This is really, you've got to work with this all the time. So I think there is scope for mediation, and I think, again, you've got to find a skilled mediator. Of course, the mediators these days who are qualified in talking directly to children to see what they want to do and then feeding back into a mediation procedure. We have a mediation practice at our office, and we can Skype various calls and have mediation calls with people living in other jurisdictions. So everything is possible and anything is possible. Where you've got that meeting of the minds, mediation will work,
yes.
but as I say, it can come at any point, a four-way meeting, a round table
yes.
meeting, whatever it's going to be.
Yes, and thank you very much.
My pleasure.
Thank you.
Thank you.
Our viewers will have seen that this is quite a complex area of the law. There's a lot of tactical considerations to take into account very early on, and we would certainly say to our viewers, take legal advice and take that advice early. As Anne says, these applications can be lost very early on, or similarly they can be won by very good planning. At the International Family Law Group, international relocation is an area that we specialise in. We've got a number of leading practitioners in the country that specialise in this area, and Anne is one of those. So that wraps up our programme for today. I hope that you've all found it useful. If you would like more information about this topic or any other topic that we've covered in our programmes, please do not hesitate to contact either myself or any one of my colleagues at the International Family Law Group. Our telephone number at the office is 0203 178 5668, or alternatively, please feel free to take a look at our website, www.iflg.uk.com. So until next week, thank you very much for tuning in. Thank you.